brings us to the last speaker for the day, which is Suraj Sanap. Suraj is a lawyer, and we must say that we are very lucky to have him as part of this.
Put that speaker on.
Okay.
Put the mic on.
So we are very lucky to have Suraj with us. Suraj currently works with C-Help, based in Pune, and he and Vivek Diwan have worked on this document which has been Happy Together, it is called, and it talks about rights of queer and trans people in intimacies. And it's been one of the first documents to come out like that, and it has been very useful for many of our discussions as well. To have Suraj as part of the network was also useful, because thanks to his hard work that we managed a petition that actually went to court, and so in some sense we managed to raise some of the issues that Veena was talking about through our petition, and maybe Suraj can tell a little bit about that and also what happened in the court.
So I'll give a list of the prayers that we raised in the petition, and then maybe I'll discuss the issues as the prayers flow. So the first prayer obviously that we sought in our petition was to say that the Special Marriage Act, especially the provisions which grant the right to solemnize and register a marriage, should be interpreted by the court in a manner that allow queer and trans people to marry under the law. So this is your prayer that gets you the foot in the door in the Supreme Court matter. From there onwards, then we try to broaden the scope of the petition and the issues we try to raise. Related to the Special Marriage Act, the second prayer we asked was that the whole framework of notice, domicile, objection under the Special Marriage Act should be struck down. Because, I'll discuss the issues later. This is the second issue. Third and fourth is a combination of the prayers on chosen families. So to say basically that the court should recognize the right of queer and trans people to form chosen families which are beyond the bounds of marriage, blood and adoption. And flowing from such a declaration, how to operationalize it is to say that such queer and trans people, unmarried people, should have the authority to nominate any person with respect to any legal right, interest, title, whether it in context of financial matters, property matters, arranging family, child custody. That such authority should be vested in queer, trans, unmarried people to appoint any person beyond constraints of marriage, blood and adoption. And lastly, that by bringing forward the issues of natal family violence against queer trans people, then to seek a remedy for that in terms of what the Supreme Court has already done for interfaith, intercaste couples in Shakti Vahini, but to read that jointly with also how courts, local high courts have dealt with protection for queer trans people. For example, in Madras High Court, the Sushma case. So I'll go prayer by prayer. So the first question being registering solemnizing marriage under the Special Marriage Act for queer trans people. So our petition simply raised this limited question, that the whole scheme of the law, which is section 4 that talks about man should be 18, man should be 21, woman should be 18. Then those tables under the law that talk about that if any two persons are marrying, then there are certain prohibited degrees that either a man or a woman are not allowed as per law to enter into a marriage with, which is typically your blood relatives, but also people on the other side of the spouse's family, their blood relatives. So our prayer with respect to Special Marriage Act was to say that these provisions should be interpreted by court in a manner that allow people of the same sex or trans people to marry under Special Marriage Act. This became a little complicated because there were several other petitions, like Chainika said that the original petitions that came before the Delhi High Court and then first came to the Supreme Court also were people from metropolitan cities, from upper caste, upper class backgrounds. So in terms of their petitions, the relief they claimed in the Supreme Court petitions was not just to seek a right to marry, but then to seek all consequential social economic rights flowing from marriage, both within the Special Marriage Act as well as outside the Special Marriage Act. For example, the Special Marriage Act says that if an interfaith couple marries under Special Marriage Act, they will not be governed by their personal law anymore. For purposes of succession to property, they will be governed by the secular Indian succession law. This is the original position of the Special Marriage Act since 1954. But recognizing that two Hindu people are marrying under the Special Marriage Act as well, the consequence of which was that they would be stopped governing by their personal laws for access to their joint Hindu family properties, as well as their children would be stopped governed by Hindu personal law for access to their parents' families. The law, the parliament then made an exception 22 years later in 1976 to say that if two Hindu people marry now under the Special Marriage Act, they will continue to be governed by their personal law. So this is one of the main issues that some petitioners that first came to court were asking. Related to that was certain batch of gender-specific wife-related provisions under the Special Marriage Act itself. For example, maintenance is gender-specific under the Special Marriage Act, wherein the husband has a duty to pay maintenance during the divorce proceedings or post permanent maintenance as well to the wife. So this is one aspect of economic security. There are several other economic security and violence against women related laws that these batch of petitions wanted reinterpretation of in a gender neutral manner for providing economic security as well as protection from violence. For example, under the Criminal Procedure Code, Section 125 CRPC also provides a remedy for the wife to seek maintenance from the husband. Under the Domestic Violence Act, married as well as unmarried women can seek remedies against the male partner. And there's provisions, of course, Domestic Violence Act also provides remedies against gender-based violence, but then there's also criminal law with like 498A that talks about married protection for married women from married men on charges of cruelty. So when these questions came up before court, which the other side, the government, then realizing that but some of us are seeking a foray into all a broader spectrum of Indian laws, not just related to Special Marriage Act, that the government basically did a decent job in fear-mongering and scaring the judges to say that this is not the court's job anymore because you will have to reinterpret all these laws. So because multiple legislative rewriting would be required, then the exercise essentially will become a legislative exercise. So this is for the parliament to decide, not for the court. Then there were certain negotiations that the petitioners tried to have within amongst ourselves, which did not come through because there was a lot of insistence on asking for application of personal law as well as gender neutrality of the wife-specific provisions, which we explained on two grounds, that we should drop these issues for the moment, and these issues that can be agitated 6 months down the line if and when there is a positive decision. One being that on day one of the hearings itself, because several parties had also filed marriage petitions under Hindu personal law. But as a compromise to the government, the court on day one itself declared that they will not enter into personal law, they will only deal with special marriage. So personal law was already out. So this was one strategic response we were trying to give them to say that the court itself is not dealing with it, so you should not agitate it. Secondly, to make those wife-specific provisions gender neutral in interests, for instance, for a lesbian couple, would then also mean that the heterosexual wife would be liable to pay maintenance to the heterosexual husband, which is an adverse and unintended consequence that we don't want to go down that path. So you leave those things untouched. You can agitate maintenance separately in a separate petition to a separate law, 6 months down the line. But these issues seem to be non-negotiable for some metropolitan upper class people. So, but by the final week of the hearings itself, the bench's mind became much more clearer to the other petitioners as well, that now it seems on the registration of marriage itself is, the bench is unclear because they think that the personal law issue and the gender specific issues all have to be read into, and without that we can't do anything. So our job in rebuttal was basically to tell them that you just give a declaration for registering marriages, everything else will follow later incrementally. So as of now, everybody's best guess is that this is just one of the options, it's not sealed. The second issue on striking down notice domicile objection is very clearly separated from the case, because the court is of the opinion that because heterosexual interfaith couples have also filed such challenges both before the Supreme Court as well as the Delhi High Court, that they want to hear both heterosexual interfaith and queer trans people joint hearing, which I think is ultimately fair. If they do give marriage first, correct. Third and fourth, the question of the declaration on right to form chosen families and the authority to nominate any person beyond marriage, blood or adoption. So we gave the court a good basis to say that, I mean, it sounds something different and novel in law, but it's actually already existing in law. For example, the definition of family, the vast majority of laws that define family itself say family is a group of persons related by marriage, blood or adoption. So when you see adoption, adoption itself is a relationship formed in law by a fiction of law, not by marriage or blood or by sex or blood. So, and this is an example that came pretty much last minute to us, so we didn't go into deep legislative debates on why adoption was recognized in law, but we gave those examples that as early as 1956 in Hindu So the idea of chosen family is already baked into the very definition of family as marriage, blood, adoption. Secondly, as Beena highlighted, the example from Mental Health Care Act. Healthcare making decision, because A, this is nowhere, there's no precedent for this in Indian law. B, this will lead to conflict between the natal family and this. In one voice by saying that this idea of appointing any person outside bonds of marriage, blood, adoption comports with international best standards of UN people with mental illness have gone through in conflict with natal family. So this is the same basis on which you are also advancing the idea of declaring and recognizing authority to nominate chosen family members outside family marriage, blood, adoption. So these are examples that are there already in Indian legislation made by Parliament. So we also give examples to court in terms of judicial examples that the court has evolved to recognize chosen families. A, again, what Chainik or we already talked about, Hijra Gharanas. So there are several high courts that recognize that people who are part of the Hijra Gharana become legal heirs of each other in terms of if one person dies, then you become the successor to their property, not the birth family. And by recognizing this explicitly, that people who follow the Guru Chela Parampara within the Hijra Gharana by longevity and by practice and by custom, that becomes the governing law for those people, and not Hindu personal law, Muslim personal law, whatever family and law, religious custom they were born in.
भी इस प्रकार की बातें आप सोचेंगे कि कैसे हम शक्ति की और दूसरे तहसील में 78 गाँवों को मिला है। ये सब कैसा हुआ?
Signals that the court will seriously apply its mind on this issue, and not just issue a declaration but also give an operational direction that unmarried queer trans people are given the authority to nominate any person outside marriage for adoption. Sorry, the last example is also this issue of passive euthanasia, that the decision that first came in 2018 by the Supreme Court. Those guidelines have been revised in February 23 now, where they say that people who've not executed advance directives, people who are terminally ill, who haven't had the opportunity to execute advance directions, and when they are faced in a healthcare facility with a situation that the doctor has to make that call on how to proceed. So for such people, the law, the Supreme Court now says that you have to consult their family or next of friend. So these are kind of legal examples that we gave the court to say that while what we are saying might be something new, but there's very much a basis in constitutional and legislative basis for this. Lastly, the question of protection from natal family violence. So our petition, as well as Mihir and Amrita, who are also friends and lawyers, who also filed a separate petition, which was argued by senior advocate Raju Ramachandran. They also raised this prayer, which is because we've handled cases of queer trans people running away, so it was, and the network has handled so many cases, so that prayer comes from there. Because you have state level high court decisions to protect people, but in terms of having a solid existing national framework, the next best option was to then pin your hopes on the Shakti Vahini protocol, where the Supreme Court devised preventive, punitive, remedial measures for state governments and the police to adopt in case interfaith, intercaste couples run away. This has already been applied for queer trans people in Delhi by the Delhi High Court. So we are telling the Supreme Court that you should allow this to cover queer trans people on a national level, not just on a local level. Secondly, Madras High Court, while just routinely dealing with a lesbian runaway couple case, has actually opened up the ambit of that case to all issues. So that's the case which became the nudge for the National Medical Commission to ban conversion therapy, where the Madras High Court judge issued orders and monitored its orders to see if it's actually implemented. So one of the issues that the court also goes into is to see that there are Garima grahas constituted by the Ministry of Social Justice for trans people in India. But the Madras High Court, because it was faced with a lesbian runaway couple, recognizes that even lesbian, gay, bisexual people run away from homes and need protection from family. So the Ministry of Social Justice should have those homes, safe shelter homes, also for all kinds of queer and trans people. And after a lot of back and forth between the ministry and the court, that we are only dealing with trans people, we are not dealing with the larger spectrum of people,